The first notice on Marcus Reed's windshield looked like one of those cheap takeout flyers. Bright paper, bold fonts, something to ignore. Only when he unfolded it at his kitchen table and saw the crest of the Ridgecrest Meadows Homeowners Association at the top did his chest tighten. This was not a coupon. It was a warning. The letter informed him that the wooden wheelchair ramp attached to his front steps violated community aesthetic standards. The board considered it an eyesore. The structure, they wrote, did not match the neighborhood's preferred design and therefore threatened property values. He had 30 days to remove it or face daily fines. Marcus stared at the page so long that his coffee went cold. The ramp was not beautiful. He knew that. It was basic pressure-treated lumber, metal brackets, and a concrete pad poured by a handyman who charged him less than half the usual rate after noticing the old army cap hanging by the door. The handyman had apologized twice for how plain it looked. Marcus had waved that away. He did not need pretty. He needed to be able to roll out of his house without begging someone to lift his chair over the steps. Stairs had become enemies after the blast in Kandahar. The improvised explosive device had thrown him into the air, taken pieces of bone and nerve from both legs, and left a pain that never really left, only shifted and changed shape. Stairs meant risk. Stairs meant falling in front of strangers. The ramp meant independence. Now a board of neighbors he barely knew was calling that independence ugly. He pinned the notice to a corkboard near the fridge, next to doctor appointments and VA paperwork. For a day or two, he tried to treat it like another form to deal with. He called the HOA office, expecting at least a human conversation. Instead, he got a flat, scripted tone from a receptionist who repeated that the board had voted unanimously. The ramp did not conform to pre-approved structures. If he wanted to keep any ramp at all, he could apply for a modification and hire the association's preferred contractor to build a new one. The estimate attached to the email that followed was more than he had paid for his car. Marcus hung up, feeling as if someone had quietly pushed him back into the chair he had spent years learning to accept. The ramp was already paid for. His disability check stretched only so far. The idea of tearing down a perfectly functional ramp and buying a more decorative version felt absurd. He tried to ignore the letter. Maybe, he thought, the board would move on to someone's unmowed lawn or mailbox color. Instead, 30 days later, a certified envelope arrived. The fines had begun. $50 for each day the ramp remained. Numbers started to pile up on his monthly statement. Marcus responded the only way he knew how. He cut back. He canceled streaming subscriptions, skipped takeout, postponed physical therapy, appointments that the VA did not fully cover. He drove less, keeping the fuel gauge as steady as he could. But every month, the HOA envelope kept coming, its balance climbing in red ink. Neighbors noticed the ramp, of course. Some offered sympathetic nods when they passed his small front yard. Others looked past him as if he were part of the landscaping. One man up the street, a retired accountant who walked his dog twice a day, liked to mention how strict the HOA had to be and how everyone needed to do their part to maintain curb appeal. He never asked how Marcus, with legs that ached from the weather, was supposed to enter his home without that sloping stretch of wood. The humiliation did something that shrapnel and surgeries never quite managed. It ate at his sense of worth. Overseas, he had known exactly what his job was. Here, He felt like a problem that needed to be hidden. His younger sister, Tiana, watched the change and grew angrier with every visit. She came by on Saturdays with groceries and papers printed from the internet. While she filled his freezer with labeled containers, she talked about the Fair Housing Act, the Americans with Disabilities Act, and cases where HOAs had been forced to back down. Marcus listened with half of his attention. He had learned the hard way that laws on paper and justice in real life were not the same thing. But as the fines crept toward an amount he could not even imagine repaying, stubborn pride was replaced by something like survival instinct. Tiana finally took his laptop herself and opened the website for the local legal aid clinic. She typed in the details while he dictated dates and amounts, adding that he was a disabled veteran and that the ramp was his only safe access to the house. When she clicked send, Marcus expected the request to fall into the kind of void where so many forms disappeared. 3 days later, an email arrived from the clinic. They believed his situation raised serious disability and housing concerns. They assigned his case to an attorney named Nadia Morales. Nadia showed up on a gray afternoon with a canvas bag full of folders and a laptop strapped over one shoulder. She was in her 30s, small, with precise gestures and the kind of calm expression Marcus had seen only on combat medics and ICU nurses. People who walked into chaos and started sorting it. She asked him to tell the story from the beginning. He described the notice, the phone call, the certified letter, the board's insistence on a more attractive ramp. He admitted quietly that the fines had reached a number that made his stomach twist every time he opened a statement. Nadia wrote everything down. She photographed the ramp from multiple angles, measuring the slope and width with a metal tape. She asked him to demonstrate how he moved from doorway to driveway. She paid particular attention to the spot where the old concrete steps had been jackhammered away, leaving faint scars on the walkway. Only when she opened her laptop did Marcus notice a photograph set as the background. Nadia, standing on courthouse steps, holding a newspaper with a headline about an accessibility victory. It was not proof that she would win, but it told him she had done this before. She explained that the HOA's actions were not just rude or inconsiderate. Under federal law, housing providers and homeowner associations had to make reasonable accommodations for people with disabilities. A ramp that allowed a wheelchair user to enter and exit his home was the textbook example of such an accommodation. Refusing to approve it, piling on fines, and insisting on an extremely expensive alternative could be unlawful discrimination. Her first move would be to send a formal demand letter to the HOA's board. It would lay out the facts, reference the statutes, and demand that the fines stop and the ramp be approved as a necessary modification. Copies would go to the federal agency that enforced the Fair Housing Act. If the HOA refused, she told him, they would escalate. Marcus signed the retainer papers with slightly trembling hands. Legal aid would represent him pro bono. His only job, Nadia said, was to tell the truth and not give up. The demand letter went out. For a week or two, the neighborhood felt strangely quiet, as if everyone were holding their breath. Marcus caught glimpses of board members walking in and out of the community center, folders in hand, expressions tight. He let himself imagine that common sense might prevail. Instead, the board returned fire. Their lawyer responded with a thick packet of documents. The letter inside sounded polished and careful. It insisted that the HOA fully supported residents with disabilities, but that all exterior modifications required pre-approval. Marcus, they said, had built the ramp without the proper application and had refused to cooperate with their guidelines. They attached photographs of other ramps in the community, shiny metal constructions that matched the color of the railings and were installed, according to the captions, by the HOA's chosen contractor. Nadia went through the material slowly. Something caught her attention, and she asked Marcus a new question. Who lived in the homes with the other ramps? He thought for a moment. The stylish aluminum ramp on Red Oak Lane belonged to an older white couple. The one with the brick base on Willow Circle belonged to a retired teacher, also white. As they compared names, a pattern emerged so obvious that Nadia almost laughed from disbelief. None of the other ramp owners were black. The board's compromise sat on the final page. If Marcus agreed to tear down his ramp, hire the HOA contractor for a replacement at his own expense, and sign a statement accepting responsibility for the violation, the association would consider waiving a portion of the accumulated fines. Marcus looked at the amount for the new build. It swallowed more than half a year of his disability payments. He pictured himself signing away his own sense of right just to stop the financial bleeding. The idea felt worse than the pain in his legs. He told Nadia he could not accept. She nodded, as if she had expected that answer. Escalation meant transforming a neighborhood annoyance into a federal case. Nadia filed complaints with the Department of Housing and Urban Development and the State Civil Rights Agency. She collected sworn statements from neighbors who had attended an HOA meeting where board members joked about the ugly ramp in front of the room. One neighbor remembered a comment about needing to keep the front rows of houses clean so buyers would not get nervous. Another recalled someone suggesting that Marcus could simply use the garage entrance if the steps caused him trouble, a suggestion that ignored the fact that the garage door had its own small but impossible ledge. Marcus learned that the meeting where his ramp had been discussed had taken place in the second-floor room of the community center, a building without an elevator. While people upstairs criticized the way he moved through the world, he physically could not have reached the room to defend himself. That detail bit into him more sharply than any line on any document. The HOA did not stop the fines while the investigation proceeded. In fact, they increased the daily amount and eventually voted to place a lien on Marcus's home. The piece of paper notifying him of the lien felt heavier than it should have, as if someone had stuffed it with lead. On paper, the association now had the right to push his property into foreclosure if the fines remained unpaid. Insomnia followed. Marcus had lived through night patrols, sandstorms, and rocket alarms. Still, something about lying awake in his own bedroom and wondering whether a committee of neighbors could take his house carried a deeper dread. Pain flared more often. His world shrank. Short trips to the grocery store became calculated missions, each step of the process measured against the question of whether he would still own this front door in a year. Nadia kept him updated. Hood had opened a file on his complaint. Investigators interviewed board members, neighbors, and Nadia herself. She believed they had more than enough to take the matter to federal court, so she drafted a lawsuit in Marcus's name, alleging discrimination and failure to provide reasonable accommodation. The case landed in the docket of a federal district judge named Daniel Archer. Marcus imagined someone distant and untouchable, a man in a black robe who lived far from Ridgecrest Meadows and its potted plants. Courts had always felt like other planets to him. Still, Nadia looked relieved when she saw the assignment. Archer, she told him, had a record of taking disability rights seriously. Once the HOA learned who their opponent would be in court, their tone shifted from smug certainty to brittle defensiveness. Their newsletters began to talk about a resident who was, in their words, attacking the community with baseless charges. They hinted that everyone's dues might go up to pay for legal fees. Some neighbors started avoiding Marcus entirely. Others quietly slipped notes of support into his mailbox, too nervous to say anything out loud. As the first hearing approached, Nadia made another request to the court. She asked that Judge Archer visit the property himself. Photographs and measurements, she argued, could not fully convey the reality of navigating the townhouses in a wheelchair. Judges were not required to grant such requests. Many preferred to rely on the written record. This judge said yes. The news came in a short email with a date and time. On that day, the court would convene not in a marble building downtown, but in the narrow driveways of Ridgecrest Meadows. The morning of the visit, Marcus woke before dawn. The sky was the pale blue he remembered from early formation back in basic training. He rolled to the front window and watched HOA board members cluster near the entrance of the community, straightening their jackets and whispering among themselves. Their attorney talked into a phone, expression tight. A black sedan with government plates pulled up to the curb a little after 9. Judge Archer stepped out, followed by a clerk and a court reporter lugging a small recording device. The judge was older than Marcus had imagined, his hair shot with gray. Most striking, though, was the black metal cane he used and the slow, deliberate way he navigated the sidewalk. Pain recognizes pain. Marcus saw it instantly in the judge's guarded movements. The small group made their way to Marcus's unit. Cameras stayed away. This was not a show for the news, just a quiet, official visit. Still, half the neighborhood seemed to find reasons to be outside at that hour. Nadia greeted the judge, introduced Marcus, and stepped back. The court reporter sat up near the curb, recording every word. Archer examined the ramp in silence first. The angle, the platform at the top, the rails worn smooth by Marcus's hands. He asked how long it had been there. He asked the HOA president to point out any specific safety concerns, aside from its appearance. The president launched into an explanation about uniformity, long-term maintenance, and property values. The judge listened without interrupting, his eyes half-lidded, his hand resting lightly on the cane. Then he asked Marcus to show him how he entered and exited the home. Marcus backed his chair up the ramp from the driveway, turned, and eased himself toward the door. He described the old days when friends had to lift his chair, the times he had nearly tipped backward, the panic of wondering whether a simple grocery run might end with him on the concrete. The judge asked whether there was another accessible entrance. Marcus explained that the back door opened onto a narrow strip of grass and a step down to uneven ground. The garage had a raised lip he could not cross without a portable ramp, which he did not own. Archer nodded as if confirming details he already suspected. He then walked, slowly, to the community center where the board held its meetings. The group stopped at the base of the stairs leading to the second-floor room. There was no ramp, no elevator, only a long flight of steps. The judge looked up, then down at his cane. He asked the HOA president whether this was the only meeting space. The president said it was. The judge went quiet for a moment that felt like an hour. Back in court a few weeks later, his written opinion arrived. The document stretched for dozens of pages, but the conclusions were clear, even to someone without legal training. The HOA had failed to provide a reasonable accommodation to a resident with a disability. The ramp was necessary for Marcus to have equal access to his home. Demanding that he pay for an expensive alternative from a preferred contractor constituted discrimination, not maintenance of aesthetics. The continuing fines and lien on his property violated federal law. Judge Archer ordered the HOA to remove the lien, cancel every fine, and formally approve the existing ramp. He also ordered the association to revise its policies, implement disability rights training for board members, and create a clear procedure for considering accommodation requests. On top of that, he granted damages to Marcus for emotional distress and inconvenience, plus attorney's fees for the legal aid clinic. Tiana read the decision aloud at Marcus's kitchen table, her voice shaking somewhere between fury and triumph. Nadia, sitting opposite, looked tired in the way people look after a long, hard battle that finally turns their way. News traveled quickly through Ridgecrest Meadows. Those who had believed the HOA's newsletters now realized that the resident in question had not attacked the community. He had defended his right to live in it. Some came by with apologies, awkward and halting. Others never said anything at all but started nodding when they passed his yard, the way people nod to someone who has become harder to ignore. A few months later, the ramp looked the same as it had the day the handyman installed it. The difference was that it no longer carried a price tag of debt and humiliation. It was simply there, the way a front door or a porch light was there. The HOA newsletter changed, too. Pages that once scolded residents about lawn length now included a small section explaining how to request accommodations and who to contact if a disability affected access to common areas. No one mentioned Marcus by name, but everyone knew whose case had forced the change. One quiet afternoon, as the sun slid over the row of identical roofs, Marcus sat at the top of the ramp and watched children pedal scooters in circles. He thought about Afghanistan, about dust and noise, and the way soldiers had built makeshift plywood ramps outside tents so wounded comrades could get inside for treatment. No one had cared how those ramps looked. Survival had been the only measure. Here, in this carefully landscaped neighborhood, he had discovered that survival could look like paperwork and hearings and a judge with a cane walking slowly around a courtyard. Justice had not come quickly or cleanly. It had come through stubbornness and the willingness of a stranger to write letters with his name at the top. The fight that started with a bright piece of paper under his windshield had ended with a federal order and a ramp that was no longer up for debate. He rolled down it once more, feeling the familiar vibration under his wheels, and understood that what had been called ugly and unwanted had become something else entirely. A line in the concrete where one man, and maybe more after him, refused to disappear from his own front step.